Good morning, and welcome to the American Enterprise Institute. I really appreciate you being here on a nice, crisp fall Thursday morning. This time last year, we did an event, we had a conversation right here called Separating Facts from Fiction, Election Disinformation on Online Platforms. So a year later, we're here to check back in and realize that there has been so much activity in this space, so we have a lot to discuss in the next hour. These issues are important as we watch Congress, the administration, the courts, state legislators, state attorney generals, and international governments take action on online content and freedom of speech in the international policy arena, not just here in the United States. Online speech is the cornerstone of modern democracy. It enables public discourse, leaders to have accountability. Social change is part of our dialogue that is being held worldwide, but we also have to manage the challenges of navigating harmful content like hate speech, misinformation, and rapidly evolving landscapes that we're seeing in areas like Israel, which we will be discussing today as well. So let me introduce you to my panel here. I'm going to start with Ari Cohen. Ari is a Chicago-based attorney and recognized expert in First Amendment, defamation, and Section 230 law. He serves as a free speech counsel at Tech Freedom, advocating for civil liberties in a digital world. Prior to joining Tech Freedom, Ari was director of Individual Rights Defense Program and the Foundation of Individual Rights for Education. He managed the program as director of advocacy and guided the organization to a record number of free speech victories on behalf of college students and faculty members across the United States. Ari has also previously served as attorney to the United States Department of Education Office of Civil Rights and litigated as an associate of the Chicago Office of Mayor Brown. Steve Del Bianco is the president and CEO of NetChoice and a prominent voice on internet governance, consumer protection, and tax issues. He advocates for the importance of internet commerce in numerous legislative councils, governing boards, enterprise initiatives, governance forums, and for the rights of private sector partners who drive today's digital economy. Steve founded Financial Dynamics, which was an IT consulting firm that grew under his leadership to a $20 million company that was acquired by a national firm in 1997, back when that was still legal. Matt Perot is currently a professor at UNC School of Information and Library Science and a consultant of a technology policy firm that he has recently created. So Open Water. I guess I had ocean and open together. He formerly led the Center on Science and Technology Policy at Duke University. Was a professor of practice at Duke Sanford School of Public Policy. He also served as the director of public policy at Facebook, where he led the company's global public policy planning efforts for Facebook, WhatsApp, and Oculus in competition, law enforcement, artificial intelligence, and human rights. He was also counsel of the Congressional Oversight Panel. He previously worked as a consultant at the World Bank and served as a law clerk for the U.S. District Court in the District of Columbia. Michael Rosen is a non-resident senior fellow with me here at the American Enterprise Institute, and we're very excited to have you here in person today. He focuses on intellectual property and technology. He is a practicing trial attorney at the Principal of Rosen Technology Law, and he also joined Arel and Mandela as counsel in 2022 to continue his work on intellectual property as a litigator who focuses on patent law and cross-border disputes. Michael has taught at the University of San Diego School of Law. And one of my colleagues who's not here today, but I highly recommend his work, is Clay Calvert. He has a piece today on Tech Policy Daily, and he is following these issues pretty much on, all the time, but he writes on it almost weekly. So to get this conversation started, Ari, I'm going to ask you to help delineate something that apparently the media gets incorrect on a regular basis. The difference between the First Amendment and the Section 230 law.
Well, the First Amendment is the thing, obviously, that prohibits the government.
It's obviously not obvious because they're getting it wrong.
It should be obvious if you've been to 7th grade. That prohibits the government from telling us what to say and what not to say. It, with the exception of, I guess, 2 Fifth Circuit judges, is what gives platforms the right to determine what content they will host on their platforms and what content they won't host on their platforms. Section 230 is a different animal. It is a liability shield, and it acts as a buttress to the First Amendment. What it does is it provides an escape hatch for when people who see things they don't like or are hurt by content online want to sue the deep pockets who host the speech rather than the people who actually created the speech. And it has two provisions. The first one provides that the hosts of user-generated content are not considered the publisher or speaker of that information. The second acts as a kind of belt and suspenders provision that says that platforms are not liable if they seek to remove content that is noxious from their platform. And so these two different provisions in Section 230 kind of act as an escape hatch where you don't have to get to discovery, you don't have to get to a lot of the thorny, time-consuming, and very costly litigation stages that you might otherwise have without Section 230. So it allows platforms to do a little bit more both in the way of permitting speech. Platforms don't have to do things like screen every single piece of content for acceptability before it goes up, which would obviously both slow things down and make everything at the scale that we know close to impossible. And it also allows them to compete with each other on their rules and say, this is the kind of community we want to have. And another platform can say, well, this is the kind of community we want to have. And whichever one people like more, they'll get the users, they'll get the money, and that's the way the marketplace should work. So we saw that tested in the Tomna and Gonzalez cases, where the plaintiffs were trying to poke some holes in Section 230 when it comes to algorithmic amplification. And to avoid a long rundown of the facts, basically, they said, well, the platform should be liable for aiding and abetting terrorist attacks because they didn't do enough to remove terrorist content and because the algorithms allegedly recommended some of it to users. Of course, it was recommended to those users and put in those thumbnail mosaics for playing next or whatever because of the inputs that the users themselves actually put in. They viewed things that made the algorithm think that's the kind of content they wanted to see. It was a mirror. It wasn't a platform saying, we want to promote ISIS content. It is, we think you're going to like ISIS content, allegedly. And the court actually sidestepped it and said, well, in any event, you really haven't even proven aiding and abetting. You haven't even alleged it properly because the platform's really just, again, it's a mirror. It's agnostic to what the content is. It's acting solely based on the user inputs. So we really didn't get like a full-fledged answer because there wasn't actually a valid claim in the first place, and arguably that could have been addressed at the lower courts in the first place, but there we were. And I think the way that it ties in and where we might see some funny business and crossover with the First Amendment is Justice Thomas in Tomna said over and over and over again how the platforms were agnostic and they didn't pre-screen content, and that's part of the reason why they weren't aiding and abetting. There was no intent. They weren't intending to actually give any support to these groups. And you saw that mirrored a little bit Judge Oldham's from the Fifth Circuit's statements about how, well, platforms can't have a First Amendment right to editorial discretion because they don't pre-screen the content. It's all ex post. It's not ex ante. And that shouldn't work. That doesn't logically flow. But it's possible that Justice Thomas, being a skeptic of the major social media platforms from previous opinions, could be laying the ground for, repeating that argument. Well, it remains to be seen.
Thanks. So that was really the case of 2023 that we expected to be much more definitive, and it was interesting the way it turned out. First of all, it didn't have the fervor that we expected, at least, from the discussion we had last year. So Steve, let's dig a little deeper on that, because there were some things in the Thomas decision that you think are going to have a longer tail in what's coming into your net choice cases. So give us some highlights on that.
Yeah, thanks, Shane. So Ari correctly teed it up, is that Justice Clarence Thomas was asking the kind of questions and wrote the kind of an opinion in Gonzalez that leads us to believe that he thinks that if he gives the platforms, Facebook, Twitter, YouTube, et cetera, if he gives the platforms the liability protections that Section 230 created, well then he might feel justified saying, since you're not going to get sued over things that Ari said, I think I can force you to carry everything Ari says, even if the platform, Facebook or Instagram, thinks that the things that's coming from this user are offensive, that violate their security and safety standards. In other words, they're lawful in America, but they're awful for the audience and the advertisers that make Facebook, Instagram, YouTube, and all of these platforms work. So we're very concerned, at least I am, that Justice Thomas, perhaps Justice Alito and Justice Gorsuch might well say that with 230 protections firmly in place, we think we can force platforms to carry everything that isn't illegal. And that would mean the end of discourse on social media platforms, because all manner of hate speech, pornography, anti-Semitic speech, all manner is legal in America, would have to be left up.
That'd be a neat trick. Congress could just pass a law saying you're not liable for anything you say, and therefore we can regulate anything you say.
Yeah, and it's early in the morning to deep dive on legal cases. So in 60 seconds,
really
I'd like
for
to
this
explain
crowd.
why Section 230 is even there, right? Because the First Amendment's 230 years old. Why did we even need 230? The good answer is it was a movie. It was The Wolf of Wall Street in the mid-90s, which was a true story. Jordan Belfort, the criminal guy that ran Stratton Oakmont, had defrauded so many investors that many of them had turned to a bulletin board service at the time, that equivalent of social media, called Prodigy. And they would try to warn their fellows on the financial bulletin board, stay away from Stratton Oakmont, they'll rip you off. Well, what did Jordan Belfort, the Wolf of Wall Street, do? He sued Prodigy for defamation because certain investors that he defrauded were writing about that on Prodigy. Well, you wouldn't think that would get anywhere, but it did. A judge in New York said Prodigy was liable for defamation on things that users typed. And he said the reason they're liable is because Prodigy does some cleanup of the posting, some of the cleanup. They try to keep hate speech, pornography, profanity off the platform. So if they do some cleanup, I think they're liable for everything. That ruling is why Chris Cox and Ron Wyden, who were both in the House at the time, that's why they sat down and wrote Section 230, moved it through Congress with a nearly unanimous vote, and it's been with us ever since. It was to stop the lawsuit abuse that would force platforms to not even allow users to type anything if it could bring a defamation suit later on.
So then move us forward to your current cases with Texas and Florida.
So in 2021, right after President Trump was kicked off of Facebook, YouTube, and Twitter, a couple of Republican governors, Governor of Florida, Ron DeSantis, Governor Abbott in Texas, said one way to score points with the MAGA crowd is to show that we're going to punish big tech for kicking the president or anyone else off their platforms. So they enacted laws that would force our platforms to carry content and could not discriminate against legal content based on the viewpoints that are expressed. So the ability to say, well, we're not going to carry content that anti-Semitic speech, we're not going to carry hate speech or pornography. So in Texas, the court granted an injunction blocking them from enacting the law, and the same thing happened in Florida. This was net choice cases versus net choice v. Florida, net choice v. Texas. And when it got to the circuit court, when the states appealed, the Fifth Circuit held for the state to say they could enforce the law, right? The 11th Circuit in Florida said, no, net choice is right. So we have a circuit split between two of them, and that's why this went to the Supreme Court. And Shane, I think as you know, the Supreme Court granted cert. They're going to hear the net choice cases probably in February. Amicus briefs are due at the end of November, first week of December. And this could be a landmark case that I think will guide how the First Amendment works with a platform, a private platform that chooses to adopt its own rules. 230 came into it as a tiny paragraph. We did not want to sue those states based on a relatively recent congressional law because Congress can simply amend or eliminate 230. We based it on the First Amendment. And it's on that basis that the court's going to have to determine.
So let's move into the challenge that the social media companies have had. Matt, you have been in this space for a very long time. So I realize you were having to deal with these things real time as they were coming up in the mid-2016 2012 to 2020. Give us kind of an idea of, did you see this coming as the days where people were lining up in your office to have a discussion with you about what was on social media?
Yes, I think actually. I mean, I think over time these issues have increased in acuteness for tech companies, but they were there when I started at Facebook in 2011, and we were really wrestling with some of these content moderation decisions. Most of the conversations that we have about content moderation and internet freedom today, I think, are glass half empty conversations. Like, I think almost everyone I've ever had has been like, and Freedom House just released another Freedom on the Net report, and it says internet freedom indices are down across the world for yet another, 8, 9, 10th consecutive year. But I actually think we're at a moment maybe where we could have a more optimistic view, at least in the short term, about where we are. And I think that's for a couple of reasons. One, as you alluded to, a year ago, we didn't know how the Gonzalez case was going to be decided, and there was a lot of concern that it was going to really gut 230 protections. And I think Ari's characterization is the right one. It's not maybe a validation of the importance of that statute, but at least we avoided some of the harm I think the community thought that we might see. We've also seen a significant decrease in the volume of Section 230 reform proposals in Congress. So my center at UNC partners with Lawfare to track Section 230 reform proposals that have been introduced in Congress. And there was a time where it was like dozens and dozens and dozens of proposals, and that has really decreased significantly. I think partly because those proposals were really getting no traction in the legislative process. But they were at the time very helpful, I think, messaging bills for members of Congress, and it seems like that message has now sort of decreased in importance. I think that's a positive thing. The second reason for optimism is because Steve has succeeded in pushing back on so much of the problematic legislation that's existed at the state level. One thing we haven't yet talked about is Net Choice's victories in California and Arkansas on child safety legislation. And when I read those decisions, I thought they were really important landmark cases in terms of pushing government to tie the thing that it is trying to address with the specific provisions of the legislation that it has actually passed. And that kind of rigor, not just in child safety, but in content moderation and other areas as well, I think is really important. I don't read them as a prohibition on regulating. And from my perspective, that is important. I think it is helpful to have smart regulation in these areas, but it is a requirement that the regulation be smart or data-driven. And I think Net Choice really played this important role in pushing those forward. The third thing I think, and Steve will tell me all the reasons that I'm wrong for optimism, is that I think the White House executive order this week is, I actually think, a promising step in terms of not taking too strong a heavy hand in regulating a nascent technology, but instead focusing more on using existing law and devoting additional resources to enforcement of existing law to address potential concerns around AI. And also, and I think this is consistent with the work that Net Choice did in the Arkansas and California cases, pushing for more information that can be used for smart governance. Those are the glass half full areas. There are some on the other side, reasons for pessimism, glass half empty. One is, I think for the reasons that we've been discussing, we had an important case in the last Supreme Court term. We have important cases this term. It's conceivable that if we're anticipating what we're going to be saying a year from now, that we'll be talking about a problematic set of judicial decisions. The second is a sort of flip side, I think, of Net Choice's great work in California and Arkansas, which is, I think, I sort of think of this as the loneliness of Steve Del Bianco. I was in a conversation with a reporter recently, and we were talking about a problematic law that had been passed and how it was likely a First Amendment violation. And the reporter said, "We haven't seen a Net Choice suit yet. We're still waiting for it." And I was like, Net Choice is holding up the entirety of the First Amendment on its own. And that is an extraordinary thing that Steve and his organization have developed the skills and expertise and capacity to do that. They play a really important role in the ecosystem. But there, I think, is a broader community beyond just Net Choice and its members who believe in the ideals that Net Choice is advocating for. And I think it's a really good thing, if you believe in First Amendment protection, that we would see a broader set of constituencies, not just industry organizations, and across the political spectrum who would support those ideas. So I hope that a year from now we're talking about a broader constituency. The third thing that I think is a reason for pessimism is, I think it's conceivable that we are back in 1996 when Section 230 was passed for AI. in that I think the rules that we have governing liability for online speech are in some ways not a great fit for a world of generative AI. I don't think, there's disagreement about this and it's very fact specific, but I think Section 230 generally probably will not protect a lot of generative AI related speech. And that will hamstring the technology, I think, in problematic ways. There are some cases where maybe we'd want to see that liability, but I think it will hamstring the technology in problematic ways. I think that means that shifts the posture that we typically have on some of these issues from we're totally fine if nothing happens because current law is totally workable, to we need a law. And we will probably need it for speech-related stuff generally. I think we probably need it for copyright, a way to think about copyright protections and liability that protects a certain component of expression that we really want, but also protects rights holders. And right now, you're in a much better position when you don't need legislation in Congress or you want legislative proposals to stop than when you do. And so the extraordinary bipartisan partnership that we saw between Representatives Cox and Wyden at the time, and the vision that they had for a law that may be imperfect in some ways, but would set the foundation for the birth of this new technology, I don't think we can have faith that our legislative process will deliver that now.
So let's go real time, Michael, to some of the work that you've done recently for us at AEI, but you are living every day. The piece that you put out, a few suggestions on social media giants struggling to handle the Hamas assault on Israel and its civilians. You did a two-part piece. So this is actually misinformation, disinformation happening in the social media teams having to decide like on a very moment by moment, what to keep up and what to take down, and you've given them some guidance. So can you walk us through that?
Sure, and thank you very much for the opportunity to be here today, Shane. I look forward to talking about moderation, intimidation, and disinformation in the context of the platforms and the conflict between Hamas and Gaza. Let me just start, if you'll indulge me for a minute, to say it's been a very difficult month for myself and for our family who live in Israel. And we have a son who's serving in the IDF and is coordinating interactions between the US military and the Israeli Defense Force, which is critical right now. And we're grateful for all of our soldiers who are fighting and really fighting for the free world. And I just wanted to dedicate my remarks to my own cousin, Alon Ohel, a 23-year-old musician who was kidnapped by Hamas terrorists on October the 7th from the music festival that we've all heard about. So Alon, we care about you, we haven't forgotten you, and we're praying for your speedy and safe return along with all the other hostages. So let me come back to the disinformation and the moderation and focus just for a moment on the issue of intimidation and threatening posts. And here I want to really commend the platforms, start with the good news, some of the optimistic news. I was actually in the Supreme Court for oral argument on the Twitter v. Tamna case that Ari brought up and characterized, I think, exactly right. It was a really interesting discussion, and one thing that stood out to me was Seth Waxman was the lawyer, the advocate for Twitter, the legendary Supreme Court oral advocate. And at one point, he got up and felt compelled to say to the justices, and I'm paraphrasing here, but Twitter wants to make clear in the clearest terms possible that we utterly condemn ISIS and everything that it stands for, right? And the fact that was an important message that Waxman, who really knows his stuff, felt that he had to deliver, I thought spoke volumes. And one thing that was clear was that Twitter made, at the time and continues to make, very strenuous efforts to weed out any sort of terrorist or actual ISIS or Hamas or whatever group, Al-Qaeda accounts, take them off the platform as much as possible. Get rid of content that specifically threatens or advocates for these different platforms. And I think in this case, so far, from what we've seen, Meta and the other platforms have announced their efforts that they've rigorously taken down tens of thousands of accounts that pop up, like weeds, to try to get onto these. So I think one thing that is worth saying at the outset is the fact that these platforms across the board have done, in my view, a commendable job so far in making sure that these these egregious organizations, these murderous groups cannot find a footing on the platforms in and of themselves. And I'm happy to come back to some of the other issues of the disinformation and moderation as we go, but I think at the outset, I think that's worth noting.
You made a very poignant piece in your first piece that you felt that these are videos, photos, and stories that need to be told, but there could still be an ability to do some gating for youth. So can you walk us through those pieces?
Absolutely. So at the very end of World War II, when General Eisenhower was marching with the troops, I think it was the 3rd U.S. Army Division, through Europe and discovered the concentration camps. And Eisenhower himself made sure to bring with him a documentarian, photographers, videographers at the time, film cameras, to document everything that he saw and that his soldiers all saw as they came there. Because he had the foresight to realize that at some point in the future, as unimaginable as it could be at the time, someone someday would try to deny that these atrocities happened there. And he had the foresight to go out and record everything, get it all down in indisputable form, and make sure that it was recorded for posterity. We're already seeing, we're not even a month since the atrocities that Hamas carried out, and already the machinery of denying what went on is already taking place among Hamas and its supporters around the world. And it's critical that that not be allowed to happen, that all of what was documented in painstaking detail, by the way, by the terrorists themselves with body cams and GoPros, that be recorded and documented and kept in places where they can be accessed for posterity so that any kind of denial will meet an untimely end. So that's important. But it's also important not just that it be documented, but that people be able to see. And here I've drawn some criticism for my views on this, and I realize this is somewhat controversial, but I think that with appropriate protections for children and for the identity of the victims and with appropriate warnings, this content should be available for the public to see, not stored in some archive, not hidden away, not because in polite society we don't want to talk about these things, but these atrocities that were carried out, I don't need to say them in this context, but you can imagine that they need to be available. And what I had proposed in my piece, and I continue to think is the right approach, and I think this is what the platforms are doing, is to make the content available, make these videos and photos available. Of course, screen them off from any children, anyone who really shouldn't be seeing this material in any sense. And of course, also provide any sorts of warnings, content warnings, to make sure that people with special sensitivities don't have access to them. And also with sensitivity to the victims, to the abductees, to those who were murdered and assaulted and beheaded. It boggles the mind to have to say this in a panel in respectable society, but to blur their faces out of respect for their dignity. But that content should be available, and I am glad to see that most of these platforms have honored that.
Thank you for bringing all that to our attention for people that are watching this from afar and wish the best for, there's no positive outcome, but a better outcome than what we're seeing today. So I really appreciate it. I have to admit, you always say, I'm like, Michael lives in Israel. And then you actually wrote in one of your pieces kind of where you were. Like, to me, it was like, he's in Miami. So I looked up your area, and on Google Maps, how many times I had to see the word bomb shelter near where you are. And I just pray for your family and you guys staying safe. So as you said the other day on a call, they may be safe, but they're not okay, and we appreciate that. So one of the challenges here is the idea of government mandates. So, you've just brought up the way that the platforms you feel have taken a responsible way to manage through this, but we still have a lot of multiple governments that want to get engaged in this discussion. So let's bring it back to that conversation, and how do we ensure that the platforms are doing what we think is appropriate for society, especially in this situation, and not necessarily, governments tend to lead from behind. And so I'm challenged by that. If we put something in place because of what recently happened, that it'll stick and then we'll lose a beat to the next technology that comes along. As Matt pointed out, I was going to try to get through the whole panel without saying AI, just because this is AI week in Washington. But with artificial intelligence, there's all the new challenges with disinformation and misinformation, which really going into the 2024 election cycle, I think a lot of us are very concerned about. So let's tackle the whole idea of government mandates, and I'm going to let it be a free-for-all. Who wants to go first?
All right, I'll
You'll
kick
get
it
a
off
bite?
with
Okay,
I'm
go.
going to kick it off with the Dr. No answer, and that is, frankly, it's our responsibility, not the government's. We choose which platforms that we are active on, that we give our dollars to. We can vote with our feet, but government mandates as to what content to keep up or what content to take down poses a threat to all of us in all of the kinds of ways that we speak. And I just frankly think that there is no real room for the government to be making these decisions. These are decisions we make for ourselves. These are decisions that we push the platforms to make and say that we will not support you if you don't make the decisions we want to make. And that's the way it should be. It's not the government's job to protect us from bad speech, and it shouldn't be. The moment that becomes not our personal responsibilities, the moment that we frankly give up a good portion of our autonomy. And that's part of what makes this country really special.
Oh, that's a great normative discussion on the way it should be. But when you turn to the First Amendment, the government cannot. The First Amendment says Congress shall make no law infringing on the freedom of the press. So it's the First Amendment that's been instructive in our cases, the net choice cases, and the net choice cases in Arkansas, California as well, that if the government wanted to limit the ability of a newspaper or Facebook, Instagram to carry content, they would have to find a way that that was illegal content, because the government cannot infringe upon the freedom of you to post a video or from the freedom of Instagram to decide to carry it. On the other hand, Instagram may decide this is just too dangerous, too provocative, too injurious to the eyes of the audience, and they may decide not to carry it, but that's their decision. And I applaud the way Michael handled it. Michael's columns have been trying to identify and encourage the platforms to exercise their First Amendment right of discretion, but exercise it in an appropriate way that has a view towards making sure that we educate people and don't allow whitewashing, and to try to be sensitive to young audiences. So you're doing it exactly the right way. You're encouraging the platforms to respond. But what would happen if the White House did that, or Congress, or a state government did that? They run straight into the First Amendment, because in America, nearly everything, no matter how awful, is pretty much lawful. You can't have, the only lawful distinctions we have are child sexual abuse material and actually direct threats of physical harm. Outside of that, everything else we see and say in America, however awful, is still lawful, and the First Amendment protects it.
This is an area, I think, where data really is the important foundation for smart public policy. And for whatever reason, and I still don't really understand it, the data on misinformation is different in a meaningful way from the current conversation around misinformation. Scott Brennan, who's in the audience, and I have co-authored a brief that's going to be coming out on Monday on generative AI and political advertising. And in that brief, we looked at 4 alleged harms related to problematic content problematic political ad content that is generated by AI. And those are harms like scale and authenticity and personalization and bias. Meaning, does misinformation at scale, larger and larger volume, have more of an effect? When misinformation is more and more authentic or more personalized, does it have more of an effect? And the data is kind of murky, so I don't want to say it like too definitively, but the data suggests overall, I think, that we over-index on those concerns, that misinformation at greater and greater scale is probably not as impactful as the current conversation would make it seem. Misinformation has a relatively limited impact on persuasion. It doesn't really change what is in your head. It might change a little bit what you do, but it doesn't really change your ideas about things. And if that's the case, if we use that data as a foundation for policymaking, I don't think we then push in directions like banning all deceptive political ad content, because that is motivated by an idea that misinformation at scale or misinformation rooted in authenticity is likely to have sort of disproportionate harm. The conclusion in our paper, the recommendations that we recommend fall into two categories. One is focusing on electoral harms as opposed to specific technologies. And Ari and I were talking in advance of the panel about some of the existing law in this area where you actually can use existing law to enforce against problematic practices. And the second is to focus on learning. And that's, again, why I think the White House executive order on AI, while imperfect, and Steve can tell us why it's really, really imperfect, but while imperfect, does, I think, will help to surface some of that information that will lead to smarter data-driven public policy.
Well, one of the things about the scale issue that you talked about is people seem to lose sight of the fact, if you're convinced that this more misinformation is going to get pumped out at scale, you're basically assuming that generative AI will only be used to put out misinformation. Right. Yeah. And that is not the case. Yeah. The amount of non-misinformation and misinformation will probably be about equal to what it is in the regular non-AI discourse. And if it's the same percentage of misinformation in the overall discourse, is that really going to make a difference? And I share your thoughts that it's probably not.
Right, and the person who decides to use ChatGPT to generate a compelling, authentic, but false story about a politician, that person is the one who is guilty of certain laws in states for electoral interference. That's the one who gets sued for defamation. It really doesn't matter whether they typed it in Microsoft Word, hand wrote it on a pad, used Gen AI, or they jumped into Photoshop to doctor up a video or photo. So the person who shares the defamatory material, who violates the law, is the one that we ought to go after. And let's examine, and I think that Matt and Scott have done so, where they've examined the adequacy of state and federal laws at addressing harms to Americans, harms in the form of bias, defamation, discrimination, deception, and fraud. If those harms are covered, no matter what technology was used, well, then let's beef up the spending so that law enforcement officials know how to go after those harms, especially if they start to occur at scale, or if it's particularly difficult to know if that was an authentic video or not.
There are two areas that we found where the data does really suggest the areas of concern. One is, as you said, bias and discrimination, and I don't want to suggest the laws in that area are necessarily perfect, but there are robust federal civil rights statutes, and as you said, state statutes on voter suppression that can be enforced and should be enforced. So that one, I think, the current state of the law is relatively strong. The second area where we found potential harm is in smaller down ballot races, and that's one that I think gets just wildly insufficient attention. It gets wildly insufficient attention by Congress, which is still sort of focused on, I think, what's going to happen in Biden versus Trump, as opposed to what's going to happen in a city council race. And there are more limited enforcement resources, I think, that go in that direction. There's more limited press attention. So like the press that we read, I think, on a daily, weekly basis is really focused on Biden versus Trump, not the city council race. And that's an area where we hope there will be kind of more active focus to try to prevent against electoral harms.
Great. So Monday is your paper
Monday,
coming
yep.
out? Right. By the way, these guys are all prolific, and you should look up their information. So I'm going to go to a couple pieces that you've written. Two more issues, because we are down to 20 minutes that I want to make sure we get through. Job owning, we're going to do that one next, and then youth harm and age gating. So just so you're prepared for that one. I'm going to start with our colleague Clay, who did a great job of explaining job owning. We were having a discussion last night about where did this phrase come from? I'm still not sure. But the way he explains it is, he says, how much verbal arm twisting and job owning can a government lawfully engage in social media companies about removing ostensibly false and harmful content before it violates the company's First Amendment free speech rights? So I think we've done a good point of keying that up. Matt, you wrote a very long, lovely, articulate piece with a former colleague, Katie Harbath, on job owning, so I highly recommend that. But because it's much more entertaining, we're going to go to Ari's piece, because I had to just get some key points out. It gets both of our next topics in one place. It says Republican AGs decide that coercive job owning is good, actually, when they do it. I'm just taking a couple pieces from your highlights from your piece. It says, it'll surprise nobody that we learned that the politicians trumpeted the First Amendment. They are generally referring only to expression that they agree with. Missouri AG Andrew Bailey took a victory lap in Missouri's lawsuit against Biden administration, it's on job owning, finding that an assortment of government actors likely to violate the First Amendment by discussing content moderation in social media platforms. So we're gonna get that on job owning, but it says it's important thing to remember that Missouri sued the government officials asserting that their pressure on social media platforms over the content was unconstitutional, and a judge agreed. The very next day, Bailey turned around and joined the other AGs in a ham-fisted, legally, these are Ari's words, ham-fisted, legally and factually inaccurate letter threatening Target over the sale of Pride Month merchandise and its support of LGBT organizations. So we have a couple topics here. Let's start with job owning. What is going on? First of all, so this is a crazy thing that I didn't know. It doesn't sound very legal for my lawyer friends up here. What is it, and why is the government having to have lawsuits over this?
Well, it's certainly not a new thing. There are cases going back decades of, for instance, in the dial-a-porn days, when district attorneys would threaten telephone companies with prosecutions, they didn't cut off the 1-900 number, accounts. So the concept is that government can put enough pressure on private parties that either A, it would obviously kind of directly violate the pressured party's First Amendment rights, or B, it would actually cause that private party to violate the First Amendment rights of third parties, and therefore kind of by transient property actually create state action and have the government be responsible for that private party's actions vis-a-vis the third party. So, there is a lot of very unsatisfying case law that is not entirely fleshed out in a lot of cases about when government pressure is sufficiently coercive or encouraging so as to create a First Amendment violation. And frankly, on a better set of facts, I would thoroughly welcome this case. As a normative matter, I think the government should butt out of these things. It's not their business. And I frankly wish platforms would tell the government to shove off a little more frequently. It would be nice.
Nice, but extremely difficult.
Yes,
That same
right.
government has all the levers of the federal government regulatory powers to,
that's exactly the
to
problem.
undermine your business through antitrust regulation, enforcement, specific cases that are brought. When DHS, Department of Homeland Security, got involved in the 2022 elections, they claimed that if the social media platforms allowed a discussion of electoral fraud, it could lead to violence, and therefore it fell into DHS's jurisdiction. And they spent $60 million trying to root out any social media discussion of electoral fraud. There's a lot of force behind the government, an FBI agent getting on the phone to tell you, not just a friendly heads up, but the FBI is part of the Department of Justice. The Department of Justice is suing Google in federal court today, just down the street. So when it matters a lot who it's coming from, and it's not just a friendly heads up, it's coercive pressure. We saw President Biden, shortly after his election, at a press conference say that because Facebook was allowing discussion of vaccine safety, that Facebook is killing people. He scarcely walked it back the next day. He said Facebook is killing people because it allows us to have a discussion of vaccines. And you have to understand that that violates the First Amendment. They are coercing, they're pressuring the platforms to act a certain way in their moderation of the speech and the news and the views that we want to share. And you even have some personal experience when you were at Facebook.
We'd love to hear about that.
Daily personal experience. I mean, this was the life of sitting on the policy team at a tech company. Was every single day was either explicitly or implicitly facing this kind of pressure. I had drinks last night with someone who's currently at the White House, and I used to work with at Facebook, and we were sort of I was asking her, like, what were your memories of this? And she said, like, daily, hearing about it, not just externally, but also reflected internally, which is an important dynamic with people saying, I just got off a meeting at the Hill, I just got off a meeting at the White House, and this is what I experienced. I think this is probably in the optimistic bucket, actually, because it's incredible that, like, as you said, like, this term came out of nowhere for lots of us, I think, but it's a common practice. I mean, I really think of it as like what happens in policy work. And the fact that there's a term that that an increasing number of people know, and there's a court case on it, I think suggests that we will see progress in coming up with a more definitive rule over the next period of time. And the sort of odd thing about it is right now there are certain political equities to it where the idea, I think, is like Democrats like this kind of pressure coming from the Biden administration. Republicans are concerned about it. So this is like the Jim Jordan hearings and document requests and stuff. But the issue is job owning is 100% bipartisan. And so if we get a rule now, I think, that Republicans are happy with and Democrats have some concerns about, I think it's very likely that if there's a change in administration, the political equities will switch. But then we will have the rule to protect platforms. And again, it will protect against activity by both
But
parties.
those political equities are also completely farcical because the Trump administration did the same exact thing
that's
repeatedly, over and over and over again.
Yeah, that's what I mean. And I think the same people now who might be skeptical of a rule will actually love the rule if the Trump administration is.
Everyone likes doing it when they do it.
Right. Yeah, exactly. And I think that is why, like, the reason, a reason if you are supportive of the general concepts on speech that we are supportive of, a reason to be very optimistic, I think, about what's happening now is it's likely that we'll get a rule where you'll have some Jim Jordan statement about why it's a positive rule, and then it will be turned around in a couple years and used to protect against pressure from
I tend to agree with
Don't use the
Steve.
courts for this. Don't use the courts necessarily. This may be done by legislation that creates a bright line rule. Jordan, Comer, and Kathy McMorris Rogers wrote a bill that has already passed the U.S. House with solely Republican support. It's a 2-page law that says that any federal employee who in their official position tries to pressure a publication or social media platform to leave up or take down content loses their job and their pension. It's not going to pass the Senate, and President Biden will sign it. But Governor DeSantis signed it. It was signed into law in May. In Florida, any employee of the state of Florida who does the same thing, it's the same bill, will lose their pension and lose their position with the state bureaucracy in the state of Florida. So that's a bright line rule that doesn't suggest that it's partisan in nature. It just says that employees have to respect the First Amendment. Congress shall make no law, government shall take no action affecting the freedom of expression.
So, and I think it's worth pointing out one entity that's become something of a force multiplier for the federal government, for the administration's job owning, unfortunately, is the traditional media here. And they're rooting for, in so many ways, for all sorts of regulations, laws, and other impositions to be put on the platforms. Partly that's an institutional thing, and partly that's just sort of how they are. And we saw this.
And their advertisers back, Mike.
Exactly. I would probably do the same thing if I were them. But that doesn't excuse it. That doesn't mean that we should accept it. And this came up very clearly in one very terrible instance in the war with Hamas, where a different rival terrorist group called Palestinian Islamic Jihad misfired a rocket that they were aiming at Israeli civilians, and that rocket crashed outside of a hospital and killed a number of Palestinian civilians in Gaza. And immediately within minutes of this happening, the New York Times ran with a headline, "Israeli airstrike kills hundreds in hospital in Gaza," right? Totally unverified, totally false. Everything about it, Israeli airstrike, no, it was a Palestinian terrorist airstrike. Kills hundreds, no. In the end, there were maybe 13 to somewhere between 12 and 50 people who were killed, which of course is terrible, but it's nowhere near hundreds. And it didn't strike a hospital, it struck a parking lot outside a hospital. In any event, Shane and I were actually both interviewed for an article that came out in a different mainstream media outlet about disinformation, right? And the first thing I said is, well, unfortunately, when it comes to disinformation, many times the call is coming from inside the house, right? That if the traditional media doesn't get its act together, then how do you expect real, genuine stories to be reported out? If it's garbage in, it's going to be garbage out. And what was astounding to me is the story that ended up being written about this that we were interviewed for started with this issue of the mainstream media getting it wrong, and then went immediately to how it's all the faults of the platforms for amplifying this message. So, you've gotta start with the basics, and if our traditional so-called reliable media can't get it right, how on earth do you expect the platforms that are simply hosting this content to do so? It's unconscionable.
I tend to agree with Steve that, and without commenting on the specifics of that one bill, I think whatever rule we're likely to get out of the Supreme Court is going to be deeply unsatisfying and probably remain very murky. It's a very, very tough issue to create a bright line rule for judicially without creating some unwieldy 18-part test that comes out different maybe multiple times in the same case. So I tend to agree that if there's going to be a more definitive, easy to adhere to solution, it will probably be legislatively.
Yeah, so there's a new term, because I'm going to take Matt's bait on the executive order on generative AI. For the most part, it lays out the need to invest and learn and be smarter about it and to make sure that existing laws can protect our citizens. But the back half of that executive order is pre-job owning. Rather than waiting until something comes out and then pressuring the platforms to take it down, the executive order requires all of the companies to go through a process of auditing whatever comes out of a Gen AI model. They call it Red Team from the Department of Defense days, where you probe the other side to see what responds. And all of you, I know, have used ChatGPT and other Gen AI and realize that when you type in a prompt twice in a row, you'll get a different answer because there's probability basis. You also know that as you refine your prompt, you can bring forth a response. It's more and more tuned to making you happy, because that is exactly what an LLM is trying to do, is to satisfy your request, right? Explain to me why net neutrality is a dumb idea, and you'll get a great answer back, right? So the red teaming and auditing, yes, the red teaming and auditing are all about forcing the companies to reduce, just read the executive order, to reduce societal harms that might arise from disinformation associated with election, associated with COVID or climate change. And this was part of the Biden administration's brag to the left in July when the first version of the EO came out as a voluntary set of commitments. They want ahead of time to pressure the companies to limit the amount of unfavorable information that a generative AI platform will put out. So it's even worse than job owning after the fact in the light of day. It's all going to happen as the bureaucrats in the White House work the companies over to prevent their models from revealing things that make the administration uncomfortable.
Okay, sorry for making this very tough topic in a quick space, but we're going to transition over what I think is a proxy for 230 in a lot of cases, is the case of youth harm and age gating. And I am going to, just to tee it up, it's from a congressional letter where it says, the Child Online Safety Act could be used to reduce any speech tied to youth stress, including LGBTQ+. COSA would open the door to suppress valuable youth political discourse in the name of mitigating anxiety and depression. Such extremism requires application of websites, not just for big social media companies, but the platforms that allow users to speak. This would prevent and mitigate harms to children is their justification. So just a quick lightning round on the challenges of bringing the youth into the process, where I think they're not Matt, you mentioned all the Section 230 bills that kind of went flat. I feel like this is their resurgence. They're coming in under it with the kids. Thoughts?
We've had a law called COPPA that said that 13-year-olds can't even use a platform without parental consent. A lot of those kids will lie about their age. But this is an effort to push it all the way up to the age of 18. And so suddenly the rights of a 17-year-old to learn about things that might make you uncomfortable will be compromised if somebody has to prove they're 18 or has verifiable parental consent from a parent they can't even find. NetChoice sued the state of California, the state of Arkansas over laws that required 2 forms of government ID if a 65-year-old man wanted to use YouTube. And that is a First Amendment violation, and it's brute force to try to get at solving perhaps a real problem. Or look at the state of Utah that said that under 18 can't be online between 10:30 p.m. and 6:30 a.m. So whether or not they're workable, whether or not the companies can nerd harder and actually deliver, you have to look at the facts and the patterns of the data of who are the collateral damage, who are the adults, who are the 17-year-olds in need of having access, And the brute force of these laws is not going to survive a First Amendment challenge.
Yeah, well, and, beyond even just the kids, and as Steve is alluding to, people use social media platforms for anonymous speech to bring attention to a lot of very important things, and that goes right out the window the second you start having to provide ID. It doesn't matter if you're allowed to use a pseudonym still. The record of who you are is still there somewhere and will be there because the company needs to be able to prove that it complied with the law, and they can't do that unless they actually retain your information. So any of these laws that say, well, you can't retain the information, that's nonsense, because how do you prove compliance? But also, just fundamentally, the idea, and I'm going to go more towards the preventing and mitigating harm to kids. First of all, anxiety, depression, all these things are caused by incredibly different things in different people. Different kids respond to content in different ways. And putting the platforms basically in charge of deciding what is in kids' best interest. First of all, if you don't trust the platforms to begin with, what on earth would make you entrust them with the decision of what is good for your kids? That makes no sense at all, just fundamentally. But also, it restricts the availability of content to effectively the most sensitive and anxiety or depression prone person on the planet, because otherwise there is no one best interests of minors as a whole. That is a concept that just doesn't exist. Every person is unique. And clearly platforms can't be the psychologist of every minor user it has. That's also nonsense. So what do you have to do? You have to basically restrict content to like the most anodyne, uninformative, non-offensive milquetoast content that actually does nothing for kids who could be out there learning about the world that they live in and what's around them, which is incredibly important in allowing them to figure out how to think critically, make decisions, form opinions for themselves before, like, we're going to toss kids into being allowed to vote when a year earlier they weren't allowed to see, candidate information on the internet or what have you. Like, it doesn't make any sense. It's bad for the kids. It puts us behind every other country in terms of having a digitally literate youth that are prepared to enter a modern workforce. It's all downside and no upside, except that it makes some people think, oh, I'll be able to sleep a little better because we did something. But they don't consider whether the something they did actually helps or makes things worse. And that's the problem with our legislators these days.
No, I agree. I will confess, as the father of 3 teenagers, that part of me is actually sympathetic to this and would be grateful. There are moments when I would think, oh, that would be great if my kids were forced somehow by someone other than me and my wife to not be on their phones and on social media quite as much. But that's not a realistic or healthy solution, in my view, to what is a challenge of overexposure, certain materials and issues of anxiety and whatnot. But ultimately, it's in my view anyway, it's a parenting issue, and children and parents and teenagers need to work together to figure out what is right for them, just as we do in every other walk of life. And having the government involved in that, I think it raises more problems than it solves.
All right, so quickly for the audience and Kate, do we have question over here? We have time, and we have a hard stop in 3 minutes, so we're gonna have some fast answers to your, I'm sure, very intellectual questions.
I tried to tweet it, but I'll abbreviate some of this. The First Amendment is, if you look at it as the writer wrote it, as redundant to the Constitution, which was an argument that he didn't need to expound it. Respecting would be used, if they using the word respecting as implies that there was an establishment. So the moral would be that the government cannot change the Lord's laws, but you would still be under the morality to, as a private citizen, be judging this based on morality. Not that the government can't play God, the government isn't supposed to do it, but you are established with the government as under God. So that's it's just on that morality. But would AI be violating a copyright to, even for a millisecond, hold a copy for comparative analysis?
And while you're answering that question, can we bring the microphone up here? Kate, over here.
You probably
Quick lightning
Sure,
round.
I could answer that second one. That there's a fair use defense, which considers how much of a copyrighted work is being used and whether it is harming the market for the use of that copyrighted work to engage in this fair use and whether that use is transformative. So briefly reading and reviewing materials probably on its own is not going to be a copyright violation, but there are a number of cases that are working their way up now involving artists in all sorts of different realms that will be resolved as time goes on.
Yeah, it's a very healthy area that we will be seeing a lot. We'll probably have a whole nother event on that at some point. All right, last question.
Really fast. Mr. Del Bianco, thank you so much for speaking and being here. NetChoice has stated that it is heightening its efforts to fight CSAM in the States, focusing on criminal intent, with generative AI allowing for unprecedented quantities of CSAM depicting child sex that are entirely digital and did not harm children in the making. Does NetChoice have a position on the First Amendment protection of fake child sex pictures and videos where there's not clear criminal intent?
Yeah, that's a great question. And we've been working hard on two issues where we think Gen AI needs new laws, CSAM and revenge porn. In both cases, the state laws making those illegal and the federal laws are sometimes framed in terms of having an image of a child or the image of a victim of revenge porn. Well, that's not the actual person, it's a rendering. So we have written modifications to state laws on both of those areas. We're actually resurfacing them on the last week of November at the ALEC annual meeting. And we believe that illegal CSAM, illegal revenge porn have already cleared any First Amendment barriers whatsoever. They are illegal speech. And we ought to do everything we can to crack down on those two scourges of the internet, both, well, online and offline.
And with that, I'm sorry, it is 10 o'clock. Thank you. Please thank my panelists for being here this morning and the great work that they're doing. And thank you all for being a wonderful audience. And